Personal representatives. A personal representative is a person who manages the property of another, either because the other person is legally disabled, dead, or because he lacks the capacity to do so. They carry out the wishes of a deceased person and are said to have stepped into the shoes of the deceased and stand in relation to the property in his estate very much as he did when he was alive. Types of personal representatives: 1. Executors. 2. Administrators. 3. Trustees. Executors are appointed by the testator himself in his will. Administrators are appointed through the process of the court where the will makes no mention of them. Circumstances when a court may appoint an administrator are as follows: 1. Where the deceased died intestate. 2. Where the will did not appoint a personal representative. 3. Where the personal representative is outside jurisdiction. 4. Where a personal representative or beneficiary applies to court for the appointment of a substituted personal representative. 5. Where there is a pending suit with regards to the validity of a will. And 6. Where in a trust there is a minority or life interest and no personal representative exists to deal with the trust. Ways of appointing personal representatives. 1. Express appointment. This occurs where a testator in a will clearly identifies the person he intends to carry out his wishes. The advantage is that it lessens the difficulty in the grant of probate by officials of the registry since the personal representatives are clearly identified. Also, it reduces the likelihood of disputes and litigation since such express appointments are less likely to be challenged. 2. Implied appointment. This appointment is not expressly made in a will but may be implied by the tenor of the will. The court may hold that there is implied appointment where a will requires a person to perform some tasks. In the Good of Cook, the testator stated that the desired one, John Goodrich, to pay all adjust debt. This was held as an implied appointment. 3. Appointment through a nominee in a will. This occurs in situations where the testator does not directly name an executor in the will but nominates another person in the will to appoint an executor after the death of the testator. 4. Appointment by operation of the law. This occurs where there are multiple executors appointed in a will. Where the executors die, the last to die among them will appoint his personal executor to administer the estate of the testator. E.g., T1 appoints E1, E2, and E3 as executors to his will. The executors all died one after the other, but before the death of E3, he made his own will and appointed F as the executor of his will. If at the death of the 3 executors, the estate of T1 has not been completely administered, F will take over the administration of the estate. He cannot take up one and leave the other. 5. Appointment by the court. This occurs where the court exercises powers to appoint a person as a personal representative of a will. A perfect example is in the case of an administrator. 6. Appointment by representation. This takes place where there is more than one executors. In the event of any of them dying, the other will carry out the duties of the executor. 7. Executor desuntort. They are not really appointed as personal representatives but are persons who have meddled with the estate of the deceased person, and because of their interference, they are held to be personal representatives of the estate of the deceased person. A good example is where a person collects the assets and pays the debts of a deceased person. He was held to be an executor desuntort. Adeniyi Jones and Josephine Martins, 1943, 9 Waka 100. Who can be appointed as a personal representative? Anybody can be appointed as a personal representative except an infant. Persons that can be appointed as personal representatives include: 1. A corporate body and a firm of partners. The partners here refer to persons who were partners in the firm as at the time the will was made. 2. Public trustees. 3. An administrator general can also come in to administer the estate of the deceased. Number of personal representatives. There is no statutory limitation on the number of executors that the testator can appoint. However, the law will not grant more than 4 executors probate. Where more than 4 persons are appointed, only the first 4 will be granted probate to act as executors. The remaining persons will stand aside and wait in case one of the executors fall out. A sole executor may be appointed. However, this is not advisable because he may die before the testator. It is thus advisable that the testator appoints at least 2 executors. Where there are multiple administrators or executors, the representation is joint in that the executors and the administrators must agree. Qualities of a personal representative. 1. He must be willing to act as a personal representative. 2. He must be available to administer the estate. Where he is outside the jurisdiction of the estate may be left to fall into comatose. 3. He should possess the requisite knowledge and skill to administer the estate. 4. He should be a person of integrity in order to honestly perform his functions as a personal representative. 5. The testator should ensure that there is no conflict of interest on the representative's part that has the tendencies of stopping him from discharging his functions. 6. He should make sure that there is harmonious relationship in any situation that more than one executor is appointed. 7. Personal representatives should have some level of literacy. And 8. They should consider the logistics and convenience and ensure that they do not appoint someone that is outside the jurisdiction of the estate. Remuneration of personal representatives. Generally, the office of the personal representative is held gratuitously. To this effect, he is not entitled to be paid for services rendered or for a time he has spent in the course of administering the estate. In the absence of any express permission for executors to charge for services and be remunerated, no such charges are permissible. Therefore, it is advisable to insert a charging clause in the will. This will permit the executors to claim remuneration for the services rendered. In regates, a solicitor who was an executor to a will submitted his bill of charges for services rendered. This was rejected in the absence of any charging clause in the will permitting him to do so. Only out-of-pocket expenses were allowed. Items covered under out-of-pocket expenses include transportation cost and cost of fuel in vehicles, cost of telephone calls, and stationaries. In MBA and Cuckoo 2016 All Federation Weekly Law Report Part 334, the respondent, a legal practitioner, was appointed executor to the estate of one G.W. Emodi Nicole, who died tested. There were 2 other executors. They all agreed to appoint the firm of the respondent as solicitor to the estate. The firm thus charged £20,000 for its services. One of the companies of the testator, which he directed in his will to be managed for 20 years, was prematurely wound up by the solicitor. The legal practitioners disciplinary committee found and held that there was no charging clause inserted in the will. The will never provided for the appointment of an executor as a solicitor to the estate. The Respondents Act amounts to unprofessional conduct contrary to Section 12 of the Legal Practitioners Act, and also for breach of trust for early winding up of a testator's company against his wishes. See Karen and Oguntokun. Exceptions to the rule. A. By order of court, the court may, upon the application of an executor for remuneration, exercise discretion to order compensation for the executor. The court will usually consider the difficulty of the task performed and whether the estate can bear the cost of the remuneration. B. Where a solicitor acts as a trustee, the rule in Craddock and Piper applies. The rule says that a solicitor, trustee, or his firm is entitled to remuneration for work done in connection with litigation on behalf of the personal representatives, jointly, except so far as the costs have been increased by virtue of his being one of the parties. This rule applies only to the executor's trustees who are law professionals and not to other professionals who are trustees of the will. C. Where the will expressly provides for a charging clause, MBA and Cuckoo 2006 for LRLR Volume 21, page 312. Very important, a charging clause is regarded as a gift to the executor. As a result of this, care must be taken that as beneficiary, he does not attest to the will. If he does so, the gift may fail Section 15 of the Wills Act. Renunciation of representation. Renunciation of representation is the express refusal by a person to take up grants of letters of administration. Renunciation has to be expressly signified in writing to the registrar of probate. Renunciation must not be partial, it must be complete. It is important to know that acts done by the executor before renunciation remains valid. There are, however, circumstances in which a personal representative loses the right to renounce representation. A perfect example is where intermeddles with the estate. Where a person renounces representation, he can only gain back his office with the leave of the court, and only where such retraction is made for the benefit of the estate. In this circumstance, the court may issue what is referred to as a citation, calling on the person to formally accept or renounce probate where the executor has failed to renounce or accept probate. Powers of personal representatives. 1. Power of right of action. With this power, he can sue and be sued on behalf of the estate of the deceased Okonya and Ikenga. When instituting an action against the estate of the deceased person, the action must be commenced in the name of the personal representatives of the deceased. The same thing applies if the estate is to institute an action against other persons. Where letters of administration is granted to personal representatives, the action must be instituted in the names of all the personal representatives, the administrators, executors of the estate of General Sani Abacha, deceased, and AKSP 2009 of Federation Weekly Law Report, Part 467 at page 1. The Supreme Court held that the action was improperly constituted and that the lower court ought to have struck out the action for being incompetent. 2. The personal representatives of an estate have the powers to postpone distribution of the estate. 3. They have the powers to sell, mortgage, and lease the property. This can be done where there is need to pay the debt and liabilities of the estate. In selling a piece of property, all the executors must execute the agreement or the deed of conveyance. However, if there is only one executor or other executors have died, the sole executor can execute the document. Odusoga and Ricketts, 7 Nigerian Law Report at Part 511. 4. Power to appropriate the assets. This is necessary in order to raise money towards the satisfaction of gifts or legacies made in the will. However, the pioneer of appropriation shall not prejudice any specific beneficiary. 5. The personal representatives have the implied authority to deal with or manage the estate. 6. They have the power to run the business or trade of the testator. The period of running the business usually will not exceed 1 year. The testator may expressly prescribe the minimum number of years the business plan should be run. NBA and Kuku. Here, the testator expressed 20 years, but the solicitor wound it up immediately. He was held to be guilty of breach of trust. 7. They have the powers to appoint trustees for infant beneficiaries. 8. They have the powers to invest in order to generate funds for the beneficiaries of the estates. 9. They have the power or right to distrain for rent. A personal representative may distrain upon land. In effect, they can't claim for arrears of rent due or accruing to the deceased. 10. They have the power to insure the estate. 11. They have the powers to delegate some of the duties, unlike the trustee, who have no authority to delegate their functions. Duties of personal representatives. 1. Duty to prove the will by applying for probate. 2. Duty to ensure that the testator is given a decent burial. 3. They have a duty to collect and gather the assets and other properties of the deceased person. Collecting or gathering of the estate may not necessarily mean physical gathering. It means placing the assets under the control of the personal representatives for the purpose of using them to pay the liabilities of the deceased and also to share the benefits. 4. To pay all liabilities and just debts of the deceased. It is only after these liabilities are settled that the remainder of the estate can be passed to the beneficiaries of the estate. 5. To ascertain beneficiaries entitled to the estate and distribute the estate among them. The properties do not belong to the personal representatives. They simply hold the properties in trust for those whom it belongs to. The personal representatives are not under any obligation to distribute the estate within the period of 1 year of the death of the deceased and cannot be compelled to do so within that period. Section 47 of the Administration of Estates Law of Lagos State. Where the deceased died intestate, his estate is to be distributed according to the prescription of the native law and custom of the deceased person. 6. The personal representatives have a duty of care towards the estate when carrying out its functions and duties. 7. The personal representative should act in good faith. 8. They have a duty to keep account and inventory. They have to account for every money flowing in and all expenses made for the administration of the estate. They should keep record of all the properties and items belonging to the estate. 9. They have a duty to issue assent to beneficiaries of real properties under the Property and Conveyancing Law. Insurance note is powered by Green Chariots Limited, makers of Soyomi Caramel Popcorn and Soyomi Cinnamon Popcorn. You can locate Green Chariots Limited at number 8 Tower Connie Close of Inema Crescent, Gwefon, Lekki, Lagos, Nigeria. Tell WhatsApp 070-1283-7857. Email info@soyomi.ng. Website www.soyomi.com.ng. And Ronums and Luxury, your choice real estate agency in Lagos, Nigeria. You can contact Ronums and Luxury for all your real estate rental requests, real estate purchase requests, title perfections and regularizations, and management of properties and real estate in Lagos, Nigeria. Ronums and Luxury is located at number 7 Tower Connie Close off Inema Crescent, Gwefon, Lekki, Lagos, Nigeria. You can call them or send a WhatsApp message via 081-4277-5425 or 091-569-1367. You can also reach them via email at ronumsandluxury@gmail.com. You can go through their catalogs of properties and contact them as well on Instagram at Ronums and Luxury, also on Facebook, Ronums and Luxury. It is also powered by Quick Glance Notes is also powered by Precious Beauty Hub, suppliers of all types of hair extensions, experts in all kinds of unisex hairstyles, massage and pedicure. You can locate Precious Beauty Hub at number 9 Ibadan Street, Okpebi, Ikeja, Lagos. You can call them or send a WhatsApp message via 070-866-5673, 068-383-80. You can also contact them on Instagram at Precious_Hub. For sponsorship and advert placements, please contact 091-259-21620 or send an email to resistandpartners.chambers@gmail.com.